All right, so good evening, welcome. Before we get started with the formal programming, I just want to go over a few housekeeping items. Restrooms are available in the main lobby on either side of the elevators. And in the event of an emergency, if you would please follow the exit signs back out to the main lobby and walk out to the second set of parking lots for your safety. Good evening. I am Michelle Thompson, Consumer Specialist with the Fairfax County Department of Cable and Consumer Services, Consumer Affairs Branch. I would like to welcome our distinguished guests, Community Association members, volunteer leaders, and industry professionals to the 2015 Virginia Legislative Forum. Thank you to the Virginia Legislative Action Committee and the Washington Metropolitan Chapter Community Associations Institute for presenting this evening's program. You will have an opportunity to participate in the program during the question and answer session. Please write down your questions on the question and answer form that is attached to the back of your packet of information. You may pass your question and answer form to your left, and staff will be able to distribute the questions to our guest speakers for a response. At this time, I'd like to turn the program over to our moderator for the evening, Rhonda DeSplinter, co-chair of the Washington Metropolitan Chapter Community Associations Institute, Virginia Legislative Committee.
Thanks, Michelle. It's my pleasure to introduce our speakers this evening, but before we do, we'd also like to thank our sponsors with whom we would not be here without them. So my co-chair is going to help me with this. Bill?
Hi, I'm Bill Maher, the co-chair with Rhonda of the Washington Metropolitan Chapter's Virginia Legislative Committee, and I want to welcome you all. I particularly want to thank Michelle and Consumer Affairs for having us here tonight, and of course I want to thank our sponsors. First, I'd like to thank CFM Management Services, and then Finley Asphalt and Sealing, Landmark Real Estate, SFMC Management, and finally yours truly, William Maher. Thank you all for contributing and sponsoring. Thank you, Pia. I appreciate that.
Thanks, Bill. It's my pleasure to introduce our speakers tonight. For those of you who are here with us, there are more comprehensive biographical summaries in the handout materials. Well, I'll provide just a few remarks as we do this. First on my left, again, William A. Maher from the Law Office of William A. Maher. Bill serves as Vice Chair of the Community Association Institute Legislative Action Committee and co-chairs with me the Metro Chapter Virginia Legislative Committee of CAI. On his left is Lucia Anna Trigiani, or Pia as most of us know her, a founding partner of the law firm Mercer Trigiani. She serves as legislative liaison to CAI's Virginia Legislative Action Committee and chairs the Virginia Common Interest Community Board. To Pia's left is Thomas A. Mazzei, founding shareholder and CEO of Cardinal Management Group, a Virginia Common Interest Community Association management firm. He's also a founding member of the Virginia Association of Community Managers and currently serves on that board. To his left is Will Washington, a founding member and principal in the firm of Chadwick, Washington, Moriarty, Elmore, and Bunn. Will concentrates his practice on the representation of community association issues for both his condominium and homeowner association clients, warranty negotiations, and the conversion of apartments to condominium associations, among other specialties. To his left is Susan Lucas, president of the Burke Center Conservancy, a homeowner association located in Burke with more than 5,600 homes and 17,000 residents. Susan is a condominium owner herself. In her professional life, Susan is director of legislative and military policy for the Reserve Officers Association. To her left is Gail Whitlock, president of Lake Ridge Parks and Recreation Association, a community association located in Lake Ridge. She also serves on the Prince William Chamber of Commerce and as board treasurer of an organization known as Action in Community Through Services. In her professional life, Gail manages the business operations for a wealth management firm. And finally, Gordon Beezer, president of the Westridge Swim and Racket Club, a homeowner association for more than 1,500 mixed dwelling units in Woodbridge. He's also an officer in a small homeowner association in Norfolk, where his family owns a second home. Gordon has a distinguished military background, and he's co-owner and chairman of a service-disabled, veteran-owned small business. These are our speakers. Thanks to everyone who agreed to participate in this program, and for our speakers, and to the audience who are going to assist us in our discussions tonight about various aspects of how legislation affects living in, managing, and operating community associations. Legislation and legislative activity are topics often not discussed by boards of directors of community associations. Not long ago, during a discussion with a board member, the question was asked, what are we doing in Richmond? We're just community associations. Well, ladies and gentlemen, the answer is we're doing a lot in Richmond, and we need to do more. Why? Because community associations are a regular part of the dialogue in Richmond. And it's important that this dialogue includes accurate and meaningful information from and about community associations. Community associations are also an active part of the engine that contributes to the economy in the Commonwealth. We often forget that. During this program, our speakers will provide a variety of information and viewpoints about recent legislation and common hot-button legislative topics that have impacted communities over several years. We'll learn about how many legislators view community associations and their governing boards. And we'll also hear from board members about their experiences and thoughts regarding legislation that impacts community associations. Let's get started. First, we have Bill Maher, who will provide an overview of the legislative activity from the 2015 General Assembly session. Bill?
Thanks, Rhonda. I'm going to talk a little bit about what happened this last session, and then Pia is going to move into an overview of trends over the last several years. This last session, which was the 2015 session, was what was called a short session, basically a 45-day session, began on January 14th and ended on February 27th. The legislature, the General Assembly in Virginia, has a short session on the odd years and then a long session on the even years. This upcoming 2016 session then will be a long session, approximately a 60-day session, preceded, as most of you know, by the election of all 140 members of the General Assembly, 40 senators and 100 members of the House of Delegates. But to get to the discussion about the 2015 session specifically, this session has been described by our lobbyists as a relatively amicable General Assembly. It was a relatively quiet session and less combative than in other years. So those are sort of the way the session has been characterized. I think our folks felt that most people were anxious to get in and get out relatively unscarred and get ready to get themselves prepared for the election that was coming up. The session that was just finished had 2,776 bills introduced and 1,508 bills passed. And I guess that it's hard to sort of understand those numbers unless you put them into some perspective. If you look at the past years, and again, this was a short session, if you look at the last 3 years, the long session had about 2014 had about 2,900 bills introduced and about 1,600 passed. The prior year, which would have been 2013, had about 2,500 bills introduced and 1,500 passed, and then the year before that, which was the 2012 session, had about 2,900 bills introduced and 1,600 passed. A lot of legislative activity in a relatively short period of time. And so I think it's important to understand that, and as we go through and talk about things from a leadership perspective, from a homeowner perspective. It's important to understand just how active things are there. The process has sometimes been described as like making sausage. It all goes in and you hope what comes out at the end of it is edible. There's a little bit of that goes on. Sessions move very quickly, bills move very quickly, and so it's important from our point of view that people have an opportunity to explain and have their legislators understand what it is associations are about, what their issues are, hopefully well ahead of time before you get into a legislative session. We're going to talk about some of the specifics of some legislation. This past session, the Legislative Action Committee, Virginia Legislative Action Committee, which is made up of representatives of the 4 Virginia chapters of CAI, and each of those chapters has members on the committee, tracked about 15 different bills. We work closely with our lobbyist, Lindell Corporation in Richmond. PIA is also coordinates between the lobbyists and our legislative committee, and as a result of that, closely follow legislation. Of those bills that were followed, 7 actually passed, and those bills became effective on the 1st of July, 2015. I'm going to talk briefly about some of them, just by way of summary. Best practices, which was a bill that was introduced by Delegate Bulova. Some of you may remember Delegate Bulova and Delegate Lemunion were part of the panel last year when we did this program. At any rate, Delegate Bulova, as a result of some of the conversation and questions that he had at the session last year, thought it was important to get legislation introduced that would be helpful to associations. What came out of that was what is called the best practices legislation. We'll talk more about that later on. Legislation, again, dealing with association meeting and quorum establishment was Delegate Pogge. That bill started out differently than it ended up. It ended up, I think, being a positive piece of legislation. Again, we'll talk a little bit more about it in a minute. Judicially convened meetings, Senator Marsden, a local senator who had a problem with one of his communities, condominium communities. They were unable to reach quorum over a 3-year period, so he came up with a piece of legislation that would effectively assist a community like that in getting a quorum, and we'll talk more about that. Corporate action without meetings. This is Delegate Kilgore's legislation, and it's one of the interesting things and byproducts of things we deal with down in Richmond. This was basically a series of amendments to the Virginia Stock Corporation Act, and what happens when the Stock Corporation Act is amended, the comparable provisions in the Virginia Non-Stock Corporation Act also tend to take on those same amendments. And because many of our property owner associations and some condominiums are incorporated entities, some of this legislation applies to them. The next 3 items listed here, resale disclosure, fees and charges, and leasing restrictions, were part of House Bill 2100. This was a Virginia Association of Realtors piece of legislation introduced by Chris Peace. The bill started out much differently than the way it ended up. It ended up as, I think, a positive piece of legislation for the industry, and we'll talk a little bit about that later. Foreclosure notice. This was a bill that was introduced in both the Senate and the House. Senator Cosgrove, former delegate, there was a growing concern among associations that in the foreclosure process, the associations were not receiving notice of the sale. So this piece of legislation addresses that. The next bill that we're going to talk about, owner rights. This was local Senator Chap Peterson's legislation. He introduced this as a homeowner bill of rights, includes 5 different aspects to it. We're going to talk a little bit about the specifics of that. The interesting thing about that piece of legislation is that legislation was actually came from the Uniform Commission of Laws. It was their model legislation. usually used with associations, usually used in states where there's not a uniform condominium act or uniform common interest community act as well. So what we'll point out when we talk more specifically about it is basically the rights that are identified in this piece of legislation are rights that are basically covered in other statutory materials. The next legislation dealing with workers' compensation insurance deals with a change in the definition of employee. We'll talk a little bit more about that. Family Day Homes legislation deals with the legislation that deals with the reduction in the number of members of a community that, or members of a house that may be subject or be part of a daycare without being licensed, dropping from 5 to 4. Conservators of the peace is a piece of legislation that was passed as a result of a Attorney General's opinion indicating that some private security in some communities may be required to have conservative of the peace status in order to function properly. Finally, private roads and parking deal with the ability of associations that have private roads to get those roads brought in under the secondary road system. So let's talk specifically about a couple of items. Delegate Bulova's legislation, House Bill 1632, in 2013, Delegate Bulova had proposed that there be a model declaration for common interest communities, for POAs. That legislation went through but was ultimately vetoed. As I mentioned earlier, Delegate Bulova was part of the program last year and again saw the need to come up with to deal with some of the issues affecting associations. And I think in his case, he particularly had a large number of older communities that had declarations that had a number of problems with them. So this legislation directs the Common Interest Community Board to develop and publish best practices as far as what should be in a declaration and consistent with the Property Owners Association Act. And P, it's my understanding that has recently been completed.
Thanks, Bill. It is under study by the Common Interest Community Board. The board will be completing its designated a committee comprised of industry representatives, homeowners, developer representatives, management companies, attorneys representing both developers and associations. And the work of that committee will conclude actually on Monday. We have our last meeting of that committee. They will present a report to the full board. The full board will then take action based on the recommendation of that committee to develop some best practices. The bill and Delegate Bulova's intent was to help associations that might be considering amending their documents, to give them a model, some tools and some ideas about what the contents of a declaration should look like. So I think the product that's coming out of the Common Interest Community Board will be very helpful.
Thank you for that update. The next piece of legislation we're going to talk about is House Bill 2055, which is Delegate Pogge's legislation, proposed legislation. As the bill was initially introduced, it would have eliminated the authority in a declaration to suspend voting privileges of delinquent owners. And as many of you know, the ability to limit voting privileges for delinquents can be an important incentive to deal with some of the delinquent situations. This bill was changed, and what it basically does now is it suspends the vote or suspended votes of delinquents will not be counted in the total number of votes required for a quorum. So that, again, was a piece of legislation that could have had a serious detrimental effect on the operation of condominiums, and was worked on, and I know Pia did a lot of work on that legislation to get the appropriate language included in there. Pia, do you want to add anything? Okay. Moving on to another amendment to the Condominium Act, Senate Bill 1390 was Senator Marsden's bill, And as I mentioned earlier, the problem he had was had a community where they had not had an annual meeting in several years because of a high quorum requirement. I believe it was 50%. What they were able to work through and develop was the opportunity that if they have worked diligently and made good faith attempts to meet that quorum requirement over a 3-year period, 3 consecutive years, then they can go to circuit court, and the court can order a meeting with a reduced quorum. So this is helpful. I know we've had some legislation in the past where where we have wanted to look to the courts to see if they can in effect help us reform documents where there are problems. I think this piece of legislation is kind of a step in that direction. The next legislation we're going to talk about is Delegate Kilgore's House Bill 1878. That's an amendment to the Virginia Non-Stock Corporation Act. As I mentioned earlier, the amendments to the Non-Stock Corporation Act, I'm not going to say were an afterthought, but the motivation behind the bill was to amend the Virginia Stock Corporation Act to make it easier to get certain corporate actions taken. And because the policy has been when you amend one, you amend the other, the Non-Stock Act got amended as well. So this act basically applies to incorporated associations, our POAs, homeowner associations, and some condominiums that are incorporated. And it allows a member to consent to a corporate action in some future time, up to 60 days out. And it pertains to certain matters related to elections. Consents must be in writing, and the person must be a member of the corporation at the time of the consent, and those consents will be valid unless revoked. So I think it's something that we need to be aware of. It's certainly something that may be available as a tool in terms of getting additional participation, and I think more to follow is what I'll say at this point. Next bill I'm going to talk about, and there are really sort of 3 sections to this, is House Bill 2100. As I mentioned earlier, this is the Virginia Association of Realtors bill. There's sort of 3 different aspects to this. Quickly, there was by way of background, the Virginia Legislative Action Committee representatives, and Pierre was one of those, certainly met with the other stakeholders, the realtors, home builders, and lenders in our industry back in October, see what kind of legislation they were proposing. They knew that something was coming from the realtors. They weren't quite sure what. This legislation didn't land, I guess, until right before the session started, or the day it started, and it was rather comprehensive. The principal purpose behind it, or one of the principal purposes behind it, was to limit the ability of associations to in any way limit rentals within their community. That was kind of the main thrust of it, and there were some other aspects as well. But what came out of this is something that I think reflects a lot of hard work and effort. And again, it was something that we really didn't get to see until right away as the session had started. Pia, do you want to mention that?
Sure, Bill. This is probably the best example, and of the bills that the legislation that Bill's reported on, it's fairly remarkable how we are able to have a conversation and kind of flip these bills around. They start out going in one direction, and we're able to influence and have some input into the process, which is why it's important to have this conversation. But House Bill 2100 is probably the best example of it. As Bill said, it was originally designed to do away with the ability of homeowners associations and condominium unit owners associations to restrict leasing. And there's a delicate balance with leasing. A lot of people think of tenants and a tenant-occupied building as a devaluation. That's not necessarily the case. but it certainly is something that the secondary mortgage market lenders look at, and it's something that most associations, I'd say it's one of the most popular amendments, is to limit the number of rentals in a community. And the realtors don't like that. They would prefer to have the ability to sell lots of property, lease property, have an unfettered, if you will, use of property by an owner. We are in Virginia, which is a private property right state, and we are very hesitant to allow restrictions, and this is one of them. And the bill, as originally presented, basically wiped out that ability. You'll see in Bill's description of it that instead what we have are some nice abilities and some new authorities for associations to know who's on the property, to know who is occupying the unit or the lot. It's some helpful information, because that's what oftentimes is a concern to the leadership of an association. The bill does a couple of other things too. One of the big things, which I think has created some question in a lot of people's minds, is it puts in the Condominium Act language that we've had in the Property Owners Association Act about the ability to charge fees, to impose charges on owners and others in a community. The language that was put into the Condominium Act is consistent with what has been the commonly held view, that an association doesn't have the authority to impose a charge, collect a charge, unless there's authority for it either in the recorded, and that's important, recorded documents, or by statute. And this bill contains that language. We were able to make sure that the ability that's currently in the statute, the Condominium Act gives a nice little bit of authority to an association to charge a user fee, a fee where an owner might have caused a charge or might be getting a service. That was exempted, accepted from the requirements or the limitations on the ability to charge. So all in all, I don't think it's a negative. In fact, I think it's a positive on that respect.
Thank you. I guess the one other provision that I'll mention about House Bill 2100 was the association, as a result, can require that the landlord provide a copy of any lease that they are using, or provide tenant and occupant information, and then finally require that a unit owner provide a tenant's acknowledgement of the association's rules and regulations. So that's additional language that is helpful. Finally, the last piece of legislation is the homeowner rights bill, which we mentioned earlier. As I said, this is actually a restatement of the provisions that are already contained in the Property Owner Association Act or the Condominium Act, and basically it affirms the rights of owners with respect to their access to books and records, again, subject to certain limitations with respect to certain kinds of documents that would ordinarily cannot be requested or have ready access to. Voting on matters that require a vote to be taken, requirement that they receive notice of board meetings, the ability to record either by video or by audio board meetings, as well as other meetings, and then a due process procedures for rule violations, and the ability to have counsel present during those proceedings. And finally, the right to be elected and to serve on a board of directions if they're a member and a member in good standing. So those are the key provisions of